Hello everyone, welcome to OnlyIAS YouTube channel. Hope you're all doing well today. So today we are going to look into our most important chapter, Salient Features. And I've been telling you that these discussions purpose is to quickly study what is most important from the prelims perspective. So without any further delay, taking you right into the topic, this is the Telegram channel, people, where you can contact me with regard to your polity doubts. You may even send the previous year questions answers here from 2013 onwards in the PDF format, as well as the public administration answers. Again, only PYQs from 2013 in the PDF format. No DMPs, no questions from other institutions, nothing. Only the previous year questions. Clear, people? So without any further delay, taking you to the introduction aspect of this chapter. So if you look into our constitution, basically, it is a borrowed constitution from multiple sources. In this chapter, we'll be looking into that. In addition to this, our constitution also has underwent a lot of amendments from the time it was actually formulated. Some of the significant amendments, if you actually see, 7th, which is state reorganization. 42nd amendment is otherwise known as the mini constitution. We will be discussing in detail about it later. 44th constitutional amendment basically made a lot of changes to the 42nd amendment, which had certain dangerous clauses were there. We will discuss about it again later. 73rd and 74th, Panchayati Raj and municipalities. 97th is constitutional status given to cooperative societies. 101st is GST. So once again, 7th, state reorganization. 42nd, 44th, in detail we will see later. 73rd, Panchayati Raj. 74th, municipalities. 97th, constitutional recognition given to cooperative societies. 101st, GST. Clear, people? Moving on. 1973, Keshavananda Bharati case. It actually gave what? The basic structure of the constitution. Supreme Court gave that particular terminology. What is it? Supreme Court has not clearly defined it. However, it is a benchmark today when it comes to interpreting the bills or provisions made by the government. And the Keshavananda Bharati case is otherwise also known as the fundamental rights case. Now let us move into the salient features of the constitution. One by one we will start seeing, starting with the lengthiest written constitution. Now why is it called the lengthiest written, or why is it so lengthy in the first place? It is the lengthiest constitution in the world. Initially, our constitution had 395 articles, 22 parts, 8 schedules, and the preamble. Today, it has the preamble again, 470 articles, 25 parts, and 12 schedules. It has various amendments have been made from 1951, which has led to deletion of 20 articles and part 7 from the constitution. What has it added? It has added 95 articles and parts. What and all parts? Parts 4A, 9A, 9B, 14A, and 4 schedules 9, 10, 11, 12. 95 articles, 4 parts, 4 schedules have been added. What are the reasons for the large size? One is the geography. Obviously, when you're having a diverse geography, you're bound to have what? Diverse types of people. So to cater to all of their aspirations, it was large. The history. Government of India Act 1935 is from where we have borrowed maximum provisions, around 250. Single constitution for center and state. Finally, the dominance of legal luminaries. If you look into the Constituent Assembly or the first government that was formed, or the overall membership of the first parliament itself, if you see, majority of them were from a legal background. And that is why the language of our constitution also is so rich. And that is why sometimes it is very difficult even to make sense out of what they have written down. Because lawyers, when they write, they will have certain phrases which they use. Because when they write, they'll try to make it watertight so that there is no question of misinterpreting it. That is why it ended up becoming very, very bulky. Then, in addition to this, it contains principles of governance. It also contains administrative provisions, and what in many countries they have left to convention. Convention means whatever practice is there, just follow it as it is, and they have left it to legislature. That is, okay, legislature, you make the law for this. In our country, we didn't leave anything like that to chance. Everything have been detailed and very clearly given there. So the detailing is so perfect that it ended up making the constitution a very bulky document. Clear. In addition to this, most states did not have a separate constitution except one, Jammu and Kashmir. But that again got revoked. Till 2019, under Article 370, Jammu and Kashmir had a separate constitution. 2019 Presidential Order, the Constitution, application to Jammu and Kashmir Order 2019, superseded the Constitution application to Jammu and Kashmir Order 1954. The 2019 order extended all the provisions of the Constitution to J&K. So every time before that, whenever you used to read your polity textbook or any data in the internet also, any bill also, always there will be a clause that this bill will apply to all the states and union territories. All the provisions of the bill will apply to all the states and union territories except J&K. That is how most bills were also formulated, because most of the central laws were not applicable to J&K till 2019. Post this order, Presidential Order 2019, that has changed. Now all the laws, whatever is applicable to any state in India, it is applicable to J&K as well. The 2019 Presidential Order basically also led to what? Jammu and Kashmir Reorganization Act 2019 bifurcated the state into two union territories of Ladakh and J&K. Taking it further forward, these schedules are actually important from prelims perspective. So we will try to study it here itself. First schedule is to do with what? States, union territories and its territory. Like jurisdiction, basically. The extent, territorial extent, that is what the first schedule is about. The second schedule is basically about emoluments, allowances, privileges and so on. For ease of remembering this, I will tell you, second schedule, try to remember it as salary. Clear? So salary of which and all people? That is the next question. President, union level. Governor, state level. Speaker, Deputy Speaker, Lok Sabha. Speaker, Deputy Speaker, Legislative Assembly. Chairman, Deputy Chairman, Rajya Sabha. Chairman, Deputy Chairman, Legislative Council. Supreme Court Judge, High Court Judge. And then CAG. Clear, people? So this is how you can remember it. Once again, President, Governor. Lok Sabha, Speaker, Deputy Speaker, Legislative Assembly, Speaker, Deputy Speaker. Chairman, Deputy Chairman, Rajya Sabha. Chairman, Deputy Chairman, Legislative Council. Supreme Court Judge, High Court Judge, finally CAG. Clear? Coming to the third schedule, which is all about what? Forms of oath or affirmations. There again, central level, union minister, state level, state minister. Central level, people who are participating in the election, that is standing as candidate for the elections to Parliament. Candidates for elections to Legislative Assembly. Then MPs, MLAs. Supreme Court, High Court, CAG. Done. Clear? So first, second and third schedule is done. Coming to the fourth schedule. Fourth schedule is all about the allocation of seats to Rajya Sabha for states and union territories. Fifth schedule is about administration of scheduled areas and scheduled tribes. Sixth schedule is about administration of tribal areas in Assam, Meghalaya, Mizoram and Tripura. Seventh schedule is about union list, state list, concurrent list. Clear? Eighth schedule is about languages. Alright. Fourth schedule, Rajya Sabha, seats. Fifth schedule, scheduled areas and scheduled tribes administration. Sixth schedule, tribal areas administration in Assam, Meghalaya, Mizoram, Tripura. Seventh schedule, union list, state list, concurrent list. Eighth schedule is all about languages. Alright, what I have given in red is the old one. How many subjects were there? What was the initial number? Today, how many are there? Languages, how many official languages there initially? Today, how many are there? Getting the point here? Now, in this again, you will note that some amendments are there. 21st Amendment included Sindhi as an official language. 71st Amendment brought in Konkani, Manipuri, and Nepali by the 71st Amendment. Clear? Then we have 92nd Amendment, Bodo, Dongri, Maithili, and Santali. Then we have the 96th Amendment, which basically changed the name of Oriya to Odia. Clear, people? So, done till 8th schedule. Now, what remains is 9, 10, 11, 12. Clear, people? Now, we will move into the 9th schedule. 9th schedule basically, for your ease of remembering things, I will call it as simply land reforms. I'll tell you what is the significance of this 9th schedule. 9th schedule simply means any law that is passed by the state, okay, with regard to land reforms or Zamindari Abolition Act cannot be questioned by the court. That means there is no judicial review for it. That was the provision. And this was included by the First Amendment. That is, 13 were added by the First Amendment Act of 1951. Whichever law you basically wanted it to escape from judicial review, what the government used to do was straight away quote it as this will come under 9th schedule, so judiciary cannot test it. Judiciary cannot question it. So initially there were 13 laws were added into it. Later the number increased to 282. Getting the point? Which means what? If you wanted to bypass the judicial test, all you had to say was, this comes under 9th schedule. That's it. Supreme Court understood this, and Supreme Court later told, laws made after 24th April 1973 are subjected to judicial review. End of the story. Clear? So 9th schedule is all about what? Land reforms. 10th schedule is to do with what? Defection. That is to prevent defection. What is defection? When a member of a particular political party, without formally resigning their post, that is, they have got elected also, it could be an MP or an MLA. All right. That is, let us say I belong to the Congress party. I won the election using the symbol, everything of Congress. People voted me thinking that I'm a Congress candidate. But after the election, I decide to go and join BJP. That is defection. Clear? Defection in detail, we'll take it up later. And defection was added later. Just like the 9th schedule, it was added later. 10th was added later by the 52nd Constitutional Amendment of 1985. 11th schedule has to do with what? Powers, authority, and responsibility of the panchayats. It contains 29 matters, means 29 subjects comes under it. 73rd Constitutional Amendment of 1992. 12th schedule, powers, authority, and responsibility of municipalities. It contains 18 matters. 74th Amendment Act. Clear, people? So this is the idea here. First schedule, states, union territory and its territory. Second schedule, salaries of president, governor, speaker, deputy speaker, speaker, deputy speaker, center and state, chairman, deputy chairman, chairman, deputy chairman, center and state, Supreme Court judge, High Court judge, CAG. Done. Third schedule, oath. Starts with union minister, state minister, MP, MLA, election to parliament, election to legislative assembly, Supreme Court, High Court, CAG. Done. Fourth schedule, seats, Rajya Sabha, union territory as well as states. Fifth schedule, administration of scheduled area, scheduled tribes. Sixth schedule, administration of tribal areas in Assam, Meghalaya, Mizoram, Tripura. Seventh schedule, union list, state list, concurrent list. Eighth schedule, languages. 21st, Sindhi. 71st, Manipuri, Konkani, Nepali. 92nd, Bodo, Santali, Maithili, and Dongri. Then finally 96th, Odisha. not Odisha, I mean related to Odisha state only. Oriya became Odia. 9th, First Amendment, 1951, land reforms. 10th, anti-defection, 52nd Amendment. 11th, Panchayat, 29 matters, 73rd. 12th, municipalities, 18 matters, 74th. Done. Clear, people? Now let us move on to the next topic, which is drawn from various sources. So drawn from various sources, when we talk about also, in that again, if you see structural part, Government of India Act of 1935, that is where we borrowed things from. How many? 250 provisions. Ransacking all the major constitutions of the world. Ransacking means we literally went through all the major constitutions, started pulling out its most important provisions which we found to be useful for us. So the philosophical part of the constitution, if you see, fundamental rights we took from USA, DPSP we took from Irish. Political part, that is a cabinet government and the relationship between the legislature and the executive, that we took from the British. Structural, Government of India Act 1935. Philosophical, fundamental rights from USA, DPSP from Irish. Political, we took it from Britain, that is cabinet form of government plus relationship between legislature and executive. Now we will move on to our next table, which is from which and all sources, what and all we took. Again, very important from prelims perspective. Let us start looking into it one by one. So let us see the provisions, whatever we have taken one by one. Government of India Act 1935, if you see, federal scheme, governor, judiciary, public service commission, emergency provision, administrative details. Clear? Federal scheme, governor, judiciary, public service commission, emergency provision, administrative details. All of this from Government of India Act 1935, 250. Then comes what? British. From British we took parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative writs, parliamentary privileges, and bicameralism. 8 things are there. Parliamentary government, rule of law, legislative procedure, cabinet system, single citizenship, prerogative writs, parliamentary privileges, and bicameralism. Clear? Then USA, fundamental rights, independence of judiciary, judicial review, impeachment of president, removal of Supreme Court and High Court judges, post of vice president. So, once again, from the top. Government of India Act of 1935. What and all we borrowed from there? Federal scheme. Okay. Then governor, judiciary, public service commission, emergency provision, administrative details. 6 things. Government of India Act 1935. Federal scheme, governor, judiciary, public service commission, emergency details, administrative provisions. Once again, 6 things. Federal scheme, governor, judiciary, then public service commission, emergency provision, administrative details. 6 things. Then comes Britain. From British, what and all we borrowed? Parliamentary government. Parliamentary government, legislative procedure. I will come to rule of law, don't worry. Legislative procedure, cabinet system, parliamentary privileges, bicameralism. There are 5 things associated with parliament alone. Parliamentary government, legislative procedure, cabinet government, parliamentary privileges, bicameralism. Again, parliamentary government, cabinet system, parliamentary privileges, bicameralism, legislative procedure. 5. rule of law, and after that, prerogative writs, finally, single citizenship. Rule of law, then writs, then single citizenship. Once again, parliamentary government, legislative procedure, then bicameralism, parliamentary privileges, cabinet form of government, legislative procedure, rule of law, writs. Over. Oh yeah, sorry, single citizenship. Only the British part, okay. So done with Government of India Act 1935. Now let us move into British. British, if you see, now this is what is given in the textbook also, correct? But I'll tell you how to go about it. Parliamentary government. Parliamentary government. Parliamentary privileges. Bicameralism. 1, 2, 3. Then, cabinet system, legislative procedure. So, if you actually look into this, 1, 2, 3, 4, 5, all these are associated, one or the other way associated with what? Parliament only. Clear? Parliamentary government, legislative procedure, cabinet form, then parliamentary privileges, bicameralism. 5 done. Then what do you have? Rule of law, writs, and finally single citizenship. Done. 5 associated with parliament. 3, one is to do with law, the other is to do with writs, then finally single citizenship. Clear? Moving on. USA. Fundamental rights. After fundamental rights, immediately think about judiciary. Where you have independence of judiciary, you have judicial review, then you have impeachment of. Okay, let us hold on to president now. Removal of Supreme Court and High Court judges. Then you have impeachment of president, and then post of VP. Fundamental rights, independence of judiciary, judicial review, removal of Supreme Court, High Court judges, impeachment of the president, appointment of VP. 6 done. American. Irish. DPSP, nomination to Rajya Sabha and election of president. Clear, people? Shall we take it from the top once again? Government of India Act 1935. Federal scheme, governor, judiciary. Shall we take it from the top again? Government of India Act 1935. Federal scheme, governor, judiciary, public service commission, administrative provision, emergency provision. 6 points done. British, I told you, 5 things associated with parliament alone. Parliamentary form of government, cabinet system, legislative procedure, parliamentary privileges, bicameralism. All right. Rule of law, writs, single citizenship. British, done. USA, fundamental rights. Associated with fundamental rights, I told you there is judiciary. Independence of judiciary, judicial review, removal of High Court and Supreme Court judges. Removal is done. Then automatically the next removal, impeachment of president, appointment of vice president. Coming to Irish, DPSP, nomination to Rajya Sabha, method of election of president, done. 1, 2, 3, 4 done. This is done. The next is easy. The next set becomes easy because you are limited only. So let us look into Canadian now. Federation with strong center, residuary powers with the center, appointment of governors by center, advisory jurisdiction of Supreme Court. 3 things, center, 1 Supreme Court. Federation with strong center, residuary powers with the center, appointment of governors by the center, finally advisory jurisdiction by the Supreme Court from Canada. Australian, Concurrent list, freedom of trade, commerce, intercourse, and joint sitting. Three things. Concurrent list, freedom of trade, commerce, intercourse, and finally you have concurrent list. Weimar of Germany, emergency provisions relating to suspension of fundamental rights. Soviet Union, fundamental duties and ideas of justice, social, economic, and political. So Canadian, federation with strong center, residuary powers with the center, appointment of governor by center, advisory jurisdiction of Supreme Court. Australian, you have concurrent list, joint sitting, freedom of trade, commerce, intercourse. Weimar of Germany, basically emergency provision suspending fundamental rights. There is an emergency provision under Government of India Act 1935. Here it is exclusively FR, and FR we took it from where? We took it from USA. Connect it like that and remember. Soviet, fundamental duties and idea of equality, justice. Once again, Soviet. And finally, Soviet, fundamental duties and ideals of justice, social, economic, political. Then French, easy, republic and ideals of liberty, equality, and fraternity, which we took from the French Revolution. South African, procedure of amendment and election of members to Rajya Sabha. Election of members to Rajya Sabha. Which one had nomination to Rajya Sabha? Put it in the comment section. Japanese, procedure established by law. Shall we revise all of that from the top? Government of India Act of 1935. So it gave us basically the federal scheme, governor, judiciary, public service commission, emergency provision, administrative details. All of this from Government of India Act. Then British, 5 provisions with regard to parliament. Parliamentary form of government, cabinet government, legislative procedure, parliamentary privileges, bicameralism, rule of law, writs, single citizenship. USA, fundamental rights, independence of judiciary, judicial review, removal of High Court, Supreme Court judge, impeachment of president, appointment of vice president. Then Irish, you basically have DPSP, nomination to Rajya Sabha and election of president. Canadian, federation with strong center, residuary powers with the center, appointment of governor by center, advisory jurisdiction of Supreme Court. Australian, when we talk about, you have concurrent list, freedom of trade, commerce, intercourse, and then joint sitting. Weimar of Germany, emergency provisions, especially with regard to suspension of fundamental rights. Soviet Union, fundamental duties and ideals of justice, social, economic, and political. French, republic and liberty, equality, and fraternity, taken from the French Revolution. South African, procedure of amendment of the constitution and election of members to Rajya Sabha. Japanese, procedure established by law. Done, people. Actually, in this chapter, the schedule and these borrowed, that is the most important. Now you can relax. Now we will deal with the other sections a little more easily. Blend of rigidity and flexibility. Why do you call it blend of rigidity and flexibility? Because it is not so easy to amend the constitution, yet it is not so difficult also. When you look at the American Constitution, it is very difficult to amend it. It is very, very difficult. That is the reason why, even though there is so many gun violence is happening in USA, we know school children are taking assault rifles, going inside the school, killing so many people. You would have always wondered, why are they not changing the law there? Because it is a constitutionally guaranteed right. Any change to that law, it requires a severe amendment, and it is not easy. The other easy constitution, which can be easily amended, is what? British. Why? Because British constitution is something where each judicial ruling, what happens is the constitution simply gets amended. And it keeps getting added on to also. Indian Constitution, you can carry it as a book in your back pocket. Small book. You can carry it in a back pocket. If anybody asks, you can just give it. Yeah, this is the Constitution. Read it. Not the British. British Constitution, if you go to the Parliament or wherever it is, you will just see one big hall and so many papers, legal documents. And if you ask them what are these papers, they'll say this is our Constitution. Because each and every time, whenever a judicial interpretation is made, especially with regard to individual rights, constitution gets amended. So our constitution is not so easy to amend, neither it is too easy nor it is too difficult. There are two major ways by which constitution can be amended. One is by special majority, which simply means 2/3 of the members present and voting and a majority of the membership of the house should approve of it. Otherwise, then second one is to special majority with ratification by half of the state legislature. Means what? 2/3 of the members present in the house and along with the majority of the membership of the house should approve it. And once it is passed in the parliament, it should get its approval from where? From at least half of the states in the country. At least half. Only then that change can be made. It is going to be very interesting because this will be in news also, especially with regard to one nation, one election. This is going to be important because there are certain provisions which can be amended by the parliament. With regard to the election, conduct of elections, there are certain provisions where parliament only need to make the amendments. But certain other provisions are there where ratification by states are also required. So it will be very interesting to see how many states will actually ratify it. Clear, people? Moving on. Federal system with a unitary bias. Nowhere in our constitution the word federation has been used. And India, first of all, it is not that we have wrote an agreement where every state came together and joined, like USA. USA, just like their name, United States of America, states came together as per an agreement. And then they decided to form the country called USA. Means what? Any state can secede from USA any point of time. It's not so easy, but yes, it is still a possibility. They can come out of it. They can tell that we don't want to be part of this union. They can come out of it. Not in India. In India, it is simply an indestructible union of destructible states. That is, even though we say India, that is Bharat, is the union of states, states' boundaries, states' names, states' territory, all this can be changed at any point of time very easily. But not India. Nobody can secede from India. Nobody can say that no, we don't want this country anymore. Nothing doing. Clear? So let us take it up further forward. Features of federation, when you say, you will clearly have two governments will be the center state. There is division of powers, legislature, executive, judiciary. Constitution is written. Constitution is supreme. It is not so easy to amend it. You have independent judiciary and bicameralism. Clear, people? Once again, there are two governments. Then there is division of power. It's a written constitution. It is a rigid constitution. Constitution is supreme. Judiciary is independent. And you have bicameralism. That means representative of the states are part of the parliament in the form of Rajya Sabha. So these are the federal features which we can see in our country. What about the unitary features? Let us see. It's a strong center. It's a single constitution. It's a single citizenship. And it's a single integrated judiciary. Constitution can be amended. Governor's post, all India service, emergency provisions. These 8 provisions clearly indicate what? We are federation with a very strong center. So once again, unitary features, if you see, you have a strong center, you have a single constitution, you have a single citizenship, single integrated judiciary, flexibility in amending the constitution, post of the governor, all India service, emergency provisions. All these will make what? Our country a federation with a strong center. Clear, people? Taking it further forward. Federation not used in the constitution. Article 1, India is a union of states, which is not an agreement. Like I told you already, states cannot secede. It is federal in form but unitary in spirit. Why? Because of the, again, why unitary in spirit? Strong center. Residuary powers borrowed from Canadian constitution lies with the center. Then single constitution, single citizenship, single integrated judiciary, flexibility, all India service, emergency provisions. Clear? It is quasi-federal, bargaining federalism, cooperative federalism, federation with a centralizing tendency. Any of these terms can be used interchangeably to describe to describe the type of federation that we have in our country. Clear, people? Taking it further forward, parliamentary form of government. So we have adopted the British parliamentary form of government. Let us see that. Adopted British parliamentary system rather than American presidential system. Parliamentary system is based on cooperation and coordination between what? Legislature and executive. What about presidential system in USA? Complete separation of powers between legislature and executive. Your presence of nominal and real executive. Nominal head and real head. Real executive means the one who is heading the government. In our country, it simply means it's either the prime minister at the union level or the CM at the state level. Nominal level, who is it? It is basically the president and governor at the state level. It's a majority party rule. Collective responsibility of executive to the legislature. That is, government is responsible to the legislature. Government answers questions in the parliament or the legislative assembly. Membership of ministers to the legislatures. Ultimately, if you look, MPs or MLAs, they are what ultimately? They are members of the parliament or members of legislative assembly respectively. You have to be an MP or an MLA. Getting the point? To be a minister. I know, even if you are not also, you have a 6-month time period. That is different. That is an exceptional case. But generally, if you see, general practice is what? You need to be an MP or an MLA if you have to become a minister. The other exception, we will take it up when we are discussing the next chapters. Leadership of PM or CM. Dissolution of the lower house. Means what? Lok Sabha can be dissolved or the legislative assembly can be dissolved. Taking it further forward, Indian parliament is not sovereign like the British parliament. Means what? In Britain, parliament is supreme. Whereas in India, constitution is supreme. And when I say constitution is supreme, who is supreme really? The people. Because constitution derives its powers from the people of our country. India has an elected head, that is president. That is why we call ourselves a republic. Anybody can become the president of India. Like if you look into the fact that the current president, Srimati Draupadi, she is from a very humble tribal background. That is impossible to imagine in Britain. In Britain, other than the royal family, nobody, that is direct heir to the royal crown. Only those people can become the head there, head of state there. Nobody, no common man or ordinary man can get into that post. While Britain has a hereditary head, monarchy, sometimes parliamentary form of government is also called prime ministerial government because it is through the prime minister that the whole thing runs. Clear, people? Moving on. Synthesis of parliamentary sovereignty and judicial supremacy. So always it is there. Is parliament supreme? Can parliament make any amendments to the law? Or is the judiciary supreme, whereby which judiciary can strike down any law passed by the parliament which judiciary feels is unconstitutional? It's a blend of both. Both are there. Let us look into that now. Sovereignty of parliament, like I told you, it is a British concept. Whereas in India, it is supremacy of judiciary. If you see, it's an American concept. So what once again. Sovereignty of parliament, it's a British concept. Supremacy of judiciary is an American concept. And American constitution gives for due process of law. Indian constitution talks about procedure established by law. Means actually what? Procedure established by law means, does the law say so? That is, only whatever punishment the law has told, only that punishment you will give. Nothing more, nothing less. You cannot give anything extra. You can only do what the law says. So it is, let us say, if I am a celebrity in USA and I was driving my car and the car met with an accident. I hit somebody. That person can literally sue me and take away, let us say, my total assets is, let us say, $500 million. That person can easily take away $100 million at least from me. Easily. That is the significance of due process of law. Because when due process of law, when you talk about, you're looking into the whole scenario holistically. That is what that individual could have achieved in their life, the level of damages, the emotional, mental trauma what that individual went through, etc., etc. And finally, the court will, considering all that and my ability to pay, all of that, they will finally award something like that. Sounds a little crazy, right? Let us come to India now. In India, it is procedure established by law. What do you mean by procedure established by law? Simply, in India, what is the punishment? In India, first of all, for such reckless driving, which led to an accident, etc., jail time is guaranteed. Financial compensation for the victim will come to what? Because a person has not died, etc., it can come to maybe maximum 1 lakh or 2 lakh, not more than that. Very rare it will be. Even this also can be challenged in a court, and again that amount can be reduced. That I need not pay this much of fine. The person is all fine. Nothing has happened. I have already bore the hospital expenses, etc. And that victim has already taken money from me multiple times. He has asked, and I've transferred it to him, etc., etc. I can tell, and ultimately court can bring that amount very, very low. Why? What is the procedure as per law? That is what is important. Scope of judicial review of Indian courts are narrower than American courts. It is a little less. Judiciary cannot literally interfere into everything here. Amendment power of Parliament and judicial review power of Supreme Court to strike down a law as unconstitutional. So both this needs to be balanced. That is, on one side you have amendment power of Parliament. Next thing is the judicial review of the Supreme Court, whereby which Supreme Court can strike down a law as unconstitutional. Best example for that will be the electoral bond scheme. Clear, people? Don't worry about the details now, because still these are just the features only. We will be discussing all this in detail when we take up the subsequent chapters on Parliament as well as Judiciary. All right, people? Taking it further forward, integrated and independent judiciary. Integrated and independent judiciary means whatever decisions are passed by the lower court, the high court, the Supreme Court, they all have validity all over India. They do have. I'm not telling all the decisions, but yes, most of them do have. Getting the point here. Lower courts are bound by the high court, high courts are bound by the Supreme Court. That is why we call it single integrated. And you have a system of appeal. From low court, you can go to high court. From high court, you can go to Supreme Court. Let us see very quickly. Single system of courts, unlike USA. That is, they have separate courts there. Independence of Supreme Court. Security of tenure of Supreme Court judges. That is, independence means, again, legislature cannot interfere in the working or the process of judiciary. Tenure of the judges are protected. Fixed service condition for the judges. All the expenses of the Supreme Court are charged on the Consolidated Fund of India. Prohibition on discussion on the conduct of judges in the legislature. That is, you cannot discuss about the conduct of judges in the legislature. Basically means you cannot criticize them. Where? Inside the Parliament or State Legislative Assembly. Similarly, the under parliamentary privileges as well as legislative assembly privileges, anything said or done inside the Parliament or Legislative Assembly cannot be questioned by the court. Simply means I won't interfere in your matter, you don't interfere in mine. Again, these will come in our subsequent chapters, need not worry. There is ban on practice after retirement, power to punish for contempt. That is, you made a statement or a comment which actually causes prejudice to the Supreme Court or to the judiciary as a whole. Court can punish you for contempt. Causing prejudice means what? That is, you develop a negative opinion on the judiciary. Genuine criticism is entertained, but you falsify the facts and data and speak or may even publish any article, that can be punished by the court. So finally we come to separation of judiciary from executive, which is also enshrined in the Constitution under Article 50. All right, people, moving on. Fundamental rights. Fundamental rights part 3. Again, there is a separate chapter on this. Very quickly we'll see right to equality 14 to 18, right to freedom 19 to 22, right against exploitation 23 to 24, right to freedom of religion 25 to 28, cultural and educational rights 29, 30, right to constitutional remedy article 32. Right to property was a fundamental right, but that was deleted by the 44th Amendment Act of 1978. That is article 31. Now it is only a legal right. Legal right, that is, it is no more a constitutional right, etc. That is, if the government tomorrow feels like taking away your property due to some national security concern, etc., they are entitled to do it. You can go to the court, you can say that my property is being taken away, etc. But then it is not a fundamental right. Fundamental right means what? Inviolable. That is, that cannot be breached, other than in very rare circumstances they are not supposed to be breached. It is qualified, I know. It is not absolute, it is only qualified. But then you could go to High Court, you could go to Supreme Court. Now that is not the case. Legal right means maximum what you can do is what? Go to the lower court, or if you want a stay, etc., you can go to the High Court. Otherwise, no. Clear? So, right to property deleted by the 44th Amendment Act. Fundamental rights features, it promotes political democracy. Why? Everybody, irrespective of caste, creed, color, sex, gender, they come under it. It limits the tyranny of the executive. Tyranny of the executive means executive cannot do anything that they wish to do. So generally, in some sections of the Western media, they address Saddam Hussein, Muammar Gaddafi as tyrants, or Idi Amin as tyrants. Why? Because they used to do whatever they liked. That you cannot do it with an elected government, because once you say these are the fundamental rights, means government cannot wreak havoc on it, other than if they don't have a valid reason. Without a valid reason, the government also cannot take away your fundamental rights. They cannot pass arbitrary laws, what and all. That is, they cannot simply pass any bill that they want to. It is justiciable in nature. That means if your fundamental rights are violated, you can approach the Supreme Court under Article 32 and the High Court under Article 226. However, it is not absolute or sacrosanct. That is, it doesn't mean that always you will be having these. Like I told you, under certain conditions, this can be taken away. Suspension during national emergency, except Articles 20 and 21. Why 20 and 21? Why not other articles? That also in the coming chapters. Clear, people? Moving forward. Directive principles of state policy. DPSP's basic purpose is ultimately to give a guideline to the states or to the government how to rule the country. What is our goal ultimately? What type of policies we need to pass? Let us see. It is a novel feature of Indian Constitution. There are three types again: socialist, Gandhian, and liberal intellectual. Idea is to promote social and economic democracy, basically welfare. Establish a welfare state. However, it is not what? It is not justiciable. That means you cannot go to a court telling that, oh, see, government is not promoting a social and economic state. I want to put a case on the government. You cannot do that. It is fundamental for governance, moral obligation on the state authorities. Real force behind them is political, that is public opinion. Means what? You have to do according to, you have to perform according to what is the public demand. What public really wants, based on that only you need to take forward your governance. Public doesn't like it, go back. Just like how the government went back on the 3 farm bills. Protest was very huge, government took a complete U-turn. Then Minerva Mills case of 1980, the Supreme Court held that Indian Constitution is founded on the bedrocks of the balance between fundamental right and DPSP. That is, both has to be balanced. Like I told you, some cases where you need to carry out a developmental project. Why? As per DPSP, it is going to bring benefits to the community. But when you look into the fundamental rights of the people, certain people are already living there. Land from them may have to be taken. So their right to life is getting affected there. Getting the point? So you need to balance both DPSP as well as fundamental rights. Which one will have an upper hand, DPSP or FR? Again, wait for it. We are coming up with those discussions in the subsequent chapters. Fundamental duties. Fundamental duties was actually added into the Constitution by the 42nd Amendment. The background to it is very simple. Indira Gandhi, at that point of time, the country was filled with protests everywhere. So at that point of time, everyone were demanding their rights. That Indira Gandhi and her government basically felt people are only thinking about their rights, they have duties also as citizen. They added this. Fundamental duties. Original constitution did not have. It was added during the internal emergency 1975 to 77. 42nd through the 42nd Constitutional Amendment Act as per the recommendations of the Swaran Singh Committee. And again, this is not justiciable. Nobody can take you to a court of law telling that, see, this person is not doing his fundamental duty. No. Fundamental duties are just again meant as a guideline for the citizens as to what they are supposed to be doing ideally. 86 Constitutional Amendment Act 2002 added one more FD. Alright, it is part of Part 4A, Article 51A. One article, one part only is there for fundamental duties. And again, like I told you, it's not justiciable. Secular state. Again, India does not have any official religion. In Pakistan, we know as soon as they got independence, they made Islam their state religion, because the whole idea behind Pakistan was what? They needed a separate country only for Muslims. That was their idea initially. Secular was added to the preamble by 42nd Constitutional Amendment Act 1976. So what do you mean by secular? Secular has got two meanings actually. That is, government will stay away from religion completely. Politics and religion will be separated. No interference. That is the negative meaning of secularism. Positive meaning of secularism simply means what? Treating all religions equally. Clear? We follow the positive meaning. So let us see. Preamble secures to all citizens liberty of belief, faith and worship. The state shall not deny any person equality before law or equal protection of the laws. Under Article 14, the state shall not discriminate against any citizen on the ground of religion. Article 15, equality of opportunity for all citizens in matters of public employment. Article 16, all persons are equally entitled to freedom of conscience and the right to freely practice, profess and propagate any religion. Article 25. So overall, if you see 14, 15, 16, 25, what is the idea that we get? Based on religion, we are not going to create any discrimination. We'll treat everybody equally. Everybody will have the same set of opportunities. Everybody, will be treated equally before law, as well as equal protection also will be there for them. Then matters of employment and to practice and profess your own faith. Taking it further forward, every religious denomination or any of its sections shall have the right to manage its religious affairs. Article 26, religious freedom. No person shall be compelled to pay any taxes for the promotion of a particular religion. 27, no religious instruction shall be provided in any educational institution maintained by the state. That is the idea here. That is, if the state is funding that institution, religious instruction of a particular religion will not be given there. If you are giving, it should be a general discussion, not a particular religion's faith is being propagated there. No religious instruction shall be, any sections of the citizen shall have the right to conserve its distinct language, script or culture. Means what? You can take any measures to protect your own language, your own culture. All minorities shall have the right to establish and administer educational institutions of their choice. Minorities means not just religious minority, it can be any sort of minority, because the word minority has not been defined anywhere in the constitution. The state shall endeavor to secure for all the citizens a uniform civil code. Article 44. That comes under the DPSP again. Clear, people? All these articles are only meant to make that point clear that we don't make any discrimination when it comes to religion. In fact, we will give all the support that is needed to, so that individually as well as a community you can practice your faith. Taking it further forward, Western concept of secularism means complete separation of religion and state. Indian concept is giving equal respect to all religions or protecting all religions equally. Constitution abolished communal electorate, which was started by the Morley-Minto reforms of 1909, provided for temporary reservation of seats for SC and ST. That is, reservation of seats are there even today for SC, ST candidates. Clear, people? Taking it further forward, universal adult franchise. Universal adult franchise at the time of independence or at the first election, minimum age was 21 years. Anybody who has more than 21 years, they will all be given what? The right to vote. Many of the Western countries or the so-called developed nations didn't do that in the initial days itself. They all gave the voting rights to people only much later. Even for women also, if you see, they gave it only much later. Whereas when we broke the shackles of colonialism, we decided we are going to give voting rights to everybody. And thus we ensured what? Political democracy, political freedom to everybody. Getting the point here. So let us see. 21 years reduced to 18 in 1989 by the 61st Constitutional Amendment Act of 1988. 71st Constitutional Amendment Act added 3 languages: Manipuri, Konkani, Nepali. Clear? This is how you constantly keep revising. Then, universal adult franchise, democracy to make it broad based, enhances the self respect and prestige of common people, especially in a country like India where caste system is so brutal. It is important that we tell everybody on that particular day, everybody equally, you are all equal, you all have the right to one vote. Upholds the principle of equality, enables minorities to protect their interests, and opens up new hopes and vistas for weaker section. So minorities can come together, they can come as a group, they can field their candidate of their choice and elect that person, and thus they get a representation or a voice in the parliament or in the legislative assembly. Clear? Moving on. Franchise to women. If you see, USA gave it only in 1920, Britain in 1928, USSR in 1936, France in 1945, Italy in 1948, and look at this, Switzerland in 1971. 24 or almost 20 years after India had given it to all the people, Switzerland has given it to their own women in their country only in 1971. So you must understand how broad-minded we were. And this is also a potential question, people, because if you look at the list here, USA, Britain, USSR, France, Italy, they all gave it before India, we can say. I know they gave it late in terms that first they gave it to men, only later they gave it to women. But year-wise, chronologically, if you see the order, all these before India, one only after India is there, and that is Switzerland. And whatever stands out odd in a list, that is what you should look out for. Your ability to look out for whatever is odd in a list, that is what UPSC wants to check also. Getting the point? So just remember this one detail here. Single citizenship. We don't have a separate citizenship for each and every state. In USA, if you see, you are a citizen of a state as well as of a country. Whereas here it is what? Just one. Clear? Then independent bodies. When you talk about independent bodies, we have, these are known as the bulwarks of the democratic system. You have Election Commission, you have CAG, you have UPSC, you have SPSC. These are all independent constitutional bodies, which we will be taking up in detail in the subsequent chapters. All India Service, Indian Civil Service became Indian Civil Service at the time of the British. It ended up getting known as Indian Administrative Service, IAS, from 1947. The Indian Police became Indian Police Service in 1947. Indian Forest Service was introduced between the years 1963 to 66. These are the 3 All India services that we have. Clear? Indian Civil Service became IAS, Indian Police became Indian Police Service, both in 1947, Indian Forest Service 63 to 66. Taking it further forward, emergency provisions. So emergency provisions, if you see, why do we need it? That is when the country is under any major threat. Then to tackle it, you need it. When a state is not behaving well or state is not carrying out its administrations properly, again you need it. So let us look into that now. National emergency during war or external aggression or armed rebellion. Armed rebellion, Article 352. 44th Amendment Act replaced the original term internal disturbance by armed rebellion. Means what? That is, the original term actually in the constitution was internal disturbance. Now when you see internal disturbance, what is internal disturbance? We don't know. What constitutes internal disturbance? Is it a riot? Is it a strike? Is it some random opposition? What it is? Not clearly defined. So the 44th Amendment Act ensured that only if an armed rebellion, internally there is an armed rebellion, means with weapons, a rebellion is there, then you can go for national emergency. That is external aggression, war, armed rebellion. Armed rebellion was added by the 44th Amendment Act, replacing internal disturbance. Then state emergency is there. But state emergency, you don't say, you generally call it what? President's rule. President's rule under Article 356 is imposed when failure of constitutional machinery in the state under Article 352. That is basically position of governor, chief minister, any constitutional machinery fails to do their job under Article 352. Then failure to comply with directions of the center, Article 365. All right. Then finally you have financial emergency. So, national emergency under Article 352. War, external aggression, armed rebellion. Armed rebellion added by 44th Amendment Act, replacing the original word internal disturbance. State emergency under Article 356. Failure of constitutional machinery, Article 352. Not following the guidelines or the directions of the center, Article 365. Financial emergency under Article 360. So far, it has not been declared. States will come under center's control. Federal structure will become unitary when during emergency. Center will take charge of the whole administration. Taking it further forward, 3-tier government you have. Originally, we had only a dual polity, but 73rd and 74th Constitutional Amendment added Panchayati Raj and municipalities also to our structure. It is not found in any other constitution of the world. All right. Panchayati Raj, Part 11. Municipalities, Part. Okay. Not found in any other constitutions in the world. 73rd and 74th. Panchayat Municipality, Part 9, Part 9A, 2 new schedules, 11 and 12. 3 types of municipalities, Nagar Panchayat, Municipal Council, Municipal Corporation. According to what? Size of the city. Transitional area, that is from a rural, it is going to become urban area. Smaller urban area, that is, it is like a city, but small. Very large urban area, you will call it Municipal Corporation. Cooperative societies. Cooperative societies, we know 97th Constitutional Amendment Act gave it constitutional status. All right. Right to form cooperative societies under Article 19. It also added a new DPSP on promotion of cooperative societies, Article 43B. New Part 9B. The cooperative societies, Article 243ZH to Article 243ZT was added. All right. Part 9, Panchayat. 9A, Municipality. 9B, you have cooperative societies. 43B, promote cooperative societies. 43B, DPSP. Then, right to form cooperative societies, Article 19. Part 9B basically talks about it should be democratic, professional, autonomous, and economically sound. All right. Parliament can frame laws when it comes to multi-state cooperative societies. That is, cooperative societies that is spread across 2 states, where members are from 2 states. Then Parliament will form. Otherwise, generally, when it comes to regulating cooperative societies within the state, means state will make laws for it. Taking it further forward. Finally, the criticism. It is known as a borrowed constitution because it has got nothing new and original. It is borrowed. It is nothing but a bag of borrowing. It is hodgepodge. That means what? Flimsy work, patchwork, cultural filtering lens. This cultural filtering lens point, it is exclusively for my PubAd students. All right. So that you need not take it down. What? Only these 3. Only these 5 we will see. Point is, even the US Constitution, if you see, most of its provisions were inspired from English laws, that is British laws. Getting the point? So it is quite natural that every constitution has got inspired from other constitutions of the world. We didn't do anything wrong here. Then Carbon copy of Government of India Act 1935. Nobody holds any patent right in fundamental ideas of constitution. That is the point here. Nobody holds any patent idea. Whatever is good, only that we have taken. We have not simply cut, copy, pasted all the provisions just as it is for either from Government of India Act 1935 or from any other constitution of the world. Some people have called it therefore because it is a copy of Government of India Act. They called it un-Indian or anti-Indian. And some have even went on to say it is a slavish imitation of the West, slavish surrender to the West. Not true. It is not at all a surrender or it is not slavery. We have only taken those provisions which we really need and which made sense to us, and we have made suitable changes to it to suit the Indian context. Un-Gandhian constitution not built on village panchayats and district panchayats. Today it doesn't have any sense in telling it because 73rd constitutional amendment ensured that panchayats were given their due. Elephantine size. It is big. Why? Because we already saw, borrowed from so many constitution, Government of India Act 1935 plus administrative provisions, governance clauses, all these are added there. Emblem in consonance with the constitution. That is what one individual told. Emblem is in consonance with the constitution. Means what? Emblem was what of the constitution? Elephant. And that elephant is in consonance with the constitution. Why? Just like the elephant, our constitution is also huge. Paradise of lawyers. Like I told you, that law language and that bulky document, the interpretation literally opened the floodgates for what? The many legal cases and petitions being filed. Opens up vast avenues for litigation. You can put complaint after complaint. So initially, so why is it that initially nobody thought about it? See, only when you put a constitution into work, only then you will get to know what are its drawbacks. Just like how through the 44th Amendment, they changed the word internal disturbance to armed rebellion. Clear, people? So with that, we come to an end of our chapter here. This is my channel again. Any queries or doubts that you have, please post it over here and let me know what else can be done to improve these classes further again. Please put it up in the comment section. Have a fantastic day, people. Happy preparation. All right. Take care.